Hello, this is Matt on the Moon Lambo channel. As the vast majority of you are undoubtedly aware at this point, we are waiting on a major ruling in the SEC v. Ripple case. We're waiting on Judge Torres to determine whether or not the SEC's claims that Judge Netburn ruled erroneously on attorney-client privilege and deliberative process privilege. We're waiting to find out whether or not Judge Torres will find that Netburn came to the wrong conclusion and arrived at conclusions perhaps improperly, or whether Judge Torres will agree with Judge Netburn that the SEC has no leg to stand on. And I think that's what's most probable, is that Judge Torres is going to side with Judge Netburn on that, and that's important because if that happens, then that will be another time that a judge in the SEC versus Ripple case is telling the SEC, no, you really super duper do need to hand over all of the emails and drafts surrounding the Billy Boy Hinman Ethereum free pass speech from June 14th, 2018. You actually have to hand that stuff over, and that is important because we in the XRP community are speculating that there may be exculpatory evidence in there, because the degree to which they're pushing back, handing over all those documents is like nothing we've ever seen from the SEC in this case. So we're waiting on that. But Attorney Filan, who is a member of the XRP community and shares all sorts of legal updates, he laid out what you might expect in terms of timeline for this case. And I'll just tell you right now, you should expect court delays if Judge Netburn does side with, if Judge Torres does side with Judge Netburn, which I personally think is most probable, expect delays. And even if this doesn't change the timeline for summary judgment arguments, which would be where the judge actually makes the final determination in terms of who's the winner, who's the loser in this case, even if this doesn't change the timeline for summary judgment arguments, we're still looking at a very long process if the SEC lawyers continue to behave like petulant children. And there also is a possibility, which would be, as Attorney Hogan points out, conjecture. I'm going to share his comments too in this video. It's possible that dates could change as a result of this. Doesn't mean it's going to, doesn't mean it's likely, but it's possible. And so I want to share with you what Attorney Filan had to say on this, as well as Attorney Jeremy Hogan. But before going any further, I do want to be clear that I do not have a legal or financial background of any kind. I'm not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun, damn it. And if you don't like it, well, you can just get out. And so here indeed is the latest update. So shout out and credit to James K. Filan, attorney and member of the XRP community. And I'm going to cover, excuse me, my apologies, good friends. I'm going to take a sip of water here. I'm going to cover the parts on that topic, what I was citing at the outset here, what I find to be most interesting here. But if you want to read the entire document, there's two pages. Page 1 is on your screen. I'm going to flip to page 2 in a minute. You can just pause if you want to read the whole thing yourself, but I'm going to highlight the parts that I found to be most interesting specifically on this topic. And so if you go to the second bullet point here, Attorney Filan wrote, the DPP, and DPP of course stands for Deliberative Process Privilege. This is an assertion that the SEC has been making time and again throughout this case, which is that when it comes to the deliberative process, they have privilege over divulging that deliberative process, everything that would be said or written down in that process. Privilege, you can't see it. That's what DPP is. So anyway, the DPP and attorney-client privilege battle over the Hinman documents. The decision on the SEC's objection is pending. This matter is fully briefed, and we are awaiting a decision by District Judge Torres. Then bullet point 3, and this is the one that might make you feel the sads. DPP appeal or petition to the Second Circuit, ? Which is why my voice goes up like this. If the SEC loses the privilege issues before District Judge Torres, there is a chance that the SEC would try to file an interlocutory appeal to the second court. And I want to pause and note just to make super duper clear in case I wasn't clear enough at the outset. The SEC is making claims of DPP, as I just referenced a moment ago, and they've also claimed attorney-client privilege. Apparently, Bill Hinman is a client of his employer and top of just being an employer there and one of the top employees. That's a claim that's being made, is what it is. But the SEC says that their claims are valid. So those two claims specifically are what we're waiting on Judge Torres to rule on, because Judge Netburn says, no, those are bogus claims, get out of here. Judge Torres, I think she's going to agree, but anyway. So moving forward, Attorney Filan says the following. Before they do that, they would have to file a motion for certification of an interlocutory appeal with District Judge Torres. Unfortunately, that takes time. For example, the last time the SEC filed such a motion before District Judge Torres in a different case, which was called SEC v. Rio Tinto, it took almost 10 weeks from the original ruling until District Judge Torres decided whether to certify the issue for appeal in that case. District Judge Torres granted the certification in Rio Tinto, but I don't think she will grant the certification in the Ripple case. And so I'll pause a note, and this is speculation so as to why Attorney Filan feels that way. I don't know, but upon reading that, it just makes me wonder if it's because the claim would be that much more absurd in comparison to this unrelated Rio Tinto case. Would it be that much more absurd? Because I'll just tell you, fine, no legal background here, but from what I've seen and having read through these documents, I just can't believe that the SEC believes what it's arguing. They're so hypocritical. Just arguing whatever they think they need to win on whatever issue, but not in the interest of what is just and what is right. That's what it looks like to me. So I'm not going to put words in Attorney Filan's mouth, but just my humble opinion. And then Attorney Filan says, but like everything in this case, it will still take some time to decide. Moreover, even if the SEC loses the certification motion, I do expect the SEC to try to get those issues before the Second Circuit, probably through a petition for a writ of mandamus. And that will also take some time to decide. The bottom line is I believe we are a long way from seeing the Hinman documents, although I cannot predict exactly when. I'm simply saying settle in, because it's going to take more time than you want. Yes, and so what does this mean for the timeline for the case? Well, at present, nothing, and we don't know exactly how this is going to unfold, but what if the SEC does keep pressing that hard, and they really insist that another court must look at this? What could that potentially mean? Well, let's kind of dive generally in that direction. There's an XRP community member named Leroy who wrote to Attorney Filan and said, "Thank you for all you do. I do have one question. Can the judge move forward with summary judgment without the possibility of DPP appeal not being settled?" And then Attorney Filan wrote, "Yes. In fact, the parties anticipated that could happen." And then they highlight this document from an SEC attorney from April 15th of this year. And I remember covering this at the time. The highlighted part from Attorney Filan reads as follows. And this is an SEC attorney writing this. The parties are to submit a proposed summary judgment schedule on April 22nd, 2022. And after meeting and conferring with defendants, the SEC understands that they do not object to proceeding to summary judgment without final resolution of their motion challenging certain of the SEC's privilege assertions. Right. And so I remember covering this back then, and then a lot of the speculation around says, well, why is Ripple okay with moving forward without that being settled? And a lot of the speculation I remember from the time, and it seemed reasonable, that the anticipation would be that this would all be settled by then. So it will be settled before then, which is why I think Ripple is happy to move forward, unless what Attorney Filan just cited, which I highlighted just a moment ago. What if Judge Torres does rule in line with Judge Netburn and says, no, SEC, you're wrong, and then the SEC throws a little tantrum like they do from time to time because they're little baby back biatchals, and then they're like, nope, another court got to see this. What's that going to do? How does that affect the timeline? Well, technically, the court dates are still set. So if anything, could that potentially result in an adjustment of current deadlines? Well, that's where we dive into this, and this thread ends up, it covers a few different things, but there's some overlap here with that topic, and it ultimately gets to Attorney Jeremy Hogan sharing his point on exactly that. So I'm just going to run through this thing, because if I just cover a bit here or there, then you're not going to have proper context, and the conversation won't flow, and it'll just get confusing. So I'm just going to cover the whole thing right here. XRP community member Stefan Huber yesterday wrote, "In a week, we will know all of the SEC's evidence. Let's hope for our protectors," in quotes, "that they have found something better than those two memos from 2013 a report that purports to show that good news affects the XRP price, and a guy who claims we believe we bought shares of Ripple. Yeah, and so of course there he's referencing in part the alleged expert witnesses the SEC has hired and the nonsense claims that undoubtedly they'll be making and have made about XRP and XRP holders. Attorney Jeremy Hogan responded with the following. He wrote, "Unless everything is filed under seal," and then in parentheses he wrote, "ducks and runs." So it's because again, Stefan's saying, "Hey, in a week we're gonna have all the SEC's evidence," and then Jeremy Hogan saying, "Yeah, unless everything's filed under seal, in which case, yeah, it'll be filed, but we won't get to see it." And then Stefan Huber says, "Why would Ripple file under seal? Because again, if they do that, we don't get to see what's being filed, right?" And attorney Jeremy Hogan says the following: "Because the judge still hasn't made it clear what should be sealed. The parties might just file the whole thing under seal to be on the safe side. It's not normal, but not much so far in this case is normal." And then somebody else responded and wrote, "Do you agree with Jim about Torres being likely to take until March to rule on summary judgment?" And attorney Hogan said the following: "I'd say bookend the end of December to the end of March, but lean towards March for a judgment. Jim is going from a historical standpoint, which is hard to argue against. I'm going with a hunch, which is difficult to defend." So I'll just pause and note there. It's not dramatically different from what Filan was saying. I wouldn't say. He's just noting a starting point that I haven't seen attorney Filan talk about, which is perfectly reasonable. He's saying from end of December to March end of March next year, 2023. That's when he anticipates summary judgment is going to come down. The end of the case, Judge Torres determining who is right and who is wrong, and all the juicy details associated with that. And of course, this all could end sooner than that if settlement is to occur. And that's still a possibility. Don't forget, I didn't mention in this video, but even if Judge Torres rules, along with Judge Netburn on this topic, the SEC may at that point not want to push back and may not want to take it to another court, even though they're petulant children. They may finally capitulate and come back to the table and agree on settlement terms. But I don't think settlement's likely to occur prior to that. Doesn't mean it can't, but I don't think it's likely to without something like that happening. And then somebody named Florence Japan Lover wrote to Jeremy Hogan on Twitter and said, "Hi, Jeremy. When you talked about your settlement time frame between now and end of November, were you including the possibility of a writ of mandamus as explained by attorney Filan? Thanks for your answer." And then attorney Hogan responds, and this is where it gets interesting, particularly interesting on the topic of when's this whole damn thing going to end. Attorney Hogan says, "Yes, the filing of a writ might change things, but that's all conjecture. I'd have to say as long as the judge doesn't change the final briefing dates, it doesn't change the case posture." So that's perfectly reasonable, but it does leave me wondering, okay, so if the SEC does continue to behave like a bunch of petulant children's and they decide to be baby back biatches and say, "Hey, no, we are really going to do everything we can to try and push this to another court," could that potentially change the timeline? Would the dates be adjusted by Judge Torres? Well, we're going to find out together in real time, aren't we, folks? That's what we're waiting for. So that's where now you're all caught up to speed. Them's all the details. I'm ready for this whole thing to be over. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.